Major breaking news. A petition for cert has just been filed by the Second Amendment Foundation and the West Virginia Citizens Defense League seeking, guess what, for the Supreme Court to hear a huge Second Amendment case next term. It is my prediction that this will be one, if not the only Second Amendment case the Supreme Court hears in the 2025-2026 term. And this deals with many constitutional issues, including whether or not 18, 19, and 20-year-olds have a right to acquire, to purchase handguns from FFLs. This is a big deal, folks. A lot of ripple effect coming out of this one if the Supreme Court takes the case. Let's break it down when we come right back. Hey folks, I'm Mark Smith, host of the Four Box of Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, before we talk about this case of West Virginia Citizens Defense League versus the ATF, I just want to remind you all that about 10 days from now, I'll be down there in Knoxville, Tennessee at the Gun Owners of America conference, the Goals Conference. I'll be doing a book signing down there with complimentary books, by the way. And I'll also be speaking on some Second Amendment topics. So if you're down there in Knoxville, Tennessee, make sure you swing on by the Gun Owners of America event and say hi to me and to say hi to some of our other friends in the Second Amendment community. It'll be fun. All right, folks, so major breaking news. We now have a petition for cert that has just been filed by the West Virginia Citizens Defense League and lawyers for the Second Amendment Foundation and the major law firm of Cooper and Kirk. They have just filed a petition for cert seeking the court to hear whether or not and decide whether or not 18, 19, and 20-year-olds have a right to acquire handguns from FFLs consistent with the Second Amendment. Before we break down the arguments, here's the question presented and the summary of what is at stake set forth by this brief on behalf of West Virginia Citizens Defense League. The question presented is whether a federal law that bans licensed sales of handguns and handgun ammunition to law-abiding 18 to 20-year-old adults violates the Second Amendment to the U.S. Constitution. After all, the right to keep and bear arms is a fundamental right necessary to our system of ordered liberty, and it belongs to all Americans. The Second Amendment thus reflects the sacred national value that part of what it means to be an American is to enjoy the right to defend yourself, your family, and your community with common firearms. By preventing an entire class of Americans, that would be law-abiding 18 to 20-year-olds, from acquiring handguns on the commercial market, this particular section of the federal code cuts to the very heart of this fundamental American value. Yet the federal courts of appeals in this country are divided over whether this restriction is constitutional. The Fifth Circuit Court of Appeals correctly struck it down in the Reese case, but the Fourth Circuit panel majority in this case upheld it as consistent with the principles that underpin our regulatory tradition. So this is a big deal, folks, because this case dealing with whether or not 18, 19, and 20-year-olds will have major ripple effects all across the broad spectrum of Second Amendment-related rights. To begin with, this case challenges a federal law. This is a federal law enforced right now by the Bureau of Alcohol, Tobacco, Firearms, and Explosives and the Trump administration. So the first thing that's going to be interesting is when the Trump administration files their brief in this particular case, what are they going to say about whether or not they want the Supreme Court to hear this case because it implicates a federal statute enforced by the DOJ? And if they want the Supreme Court to hear this case, what substantive position will the Department of Justice on behalf of Donald Trump and Pam Bondi take with respect to the various legal issues presented in this particular case? Now, just to give you some of the issues that will have to be dealt with by this case, which is why I think it would be very good for the Supreme Court to hear this case, even if you're not 18, 19, or 20 years of age, the reality is the decision in this particular case, if it is done the right way, will substantially broaden the right to keep and bear arms in many respects and add tremendous protections to it by virtue of reaffirming, if you will, the NYSERPA versus Bruin methodology, which is very good for the Second Amendment because it eliminates in all respects the sort of good guns, bad guns, interest balancing that we see with other constitutional rights like in the First Amendment context, which is very, very bad for the right to keep and bear arms because it allows these unelected judges who don't like the Second Amendment to basically balance away something they hate, which is private gun ownership in the context of private self-defense, self-defense, which is our culture we have in the United States. We don't just have a gun culture, we have a private self-defense oriented gun culture with private gun ownership. That's different than a generic gun culture. So with that said, the first question that's going to have to be decided by the U.S. Supreme Court, if they take this case, and I think they're going to take this case, and the reason why I think they're going to take this case is right now, in the year of our Lord, 2025, in August of 2025, we have a very clear circuit split. There are 6 courts of appeals right now that have addressed the question of whether or not 18, 19, and 20-year-old American young adults today have full-blown Second Amendment rights. 3 of those courts of appeals have said that they don't have Second Amendment rights, and 3 courts of appeals say they do. Specifically, the courts that are the good courts are the U.S. Court of Appeals for the Fifth Circuit, the U.S. Court of Appeals for the 8th Circuit, which is out of Missouri in the Midwest, Minnesota, and the like. Then you have the U.S. Court of Appeals out of the 3rd Circuit, which covers Delaware, Pennsylvania, and New Jersey. Those 3 courts have ruled in favor of the Second Amendment on behalf of 18, 19, and 20-year-olds, not only for the purposes of whether or not those young adults have the right to acquire guns, but also they have the right to carry guns in the context of, for example, a case out of Minnesota. In contrast, you have 3 courts of appeals that have got it totally wrong. They're sort of the usual suspects. In some ways, you have the 4th Circuit Court of Appeals in an opinion by Judge Harvey Wilkinson, who you know is terrible on the Second Amendment, actively campaigns, in my opinion, against the Second Amendment. He ruled that 18, 19, and 20-year-olds do not have the right to keep arms. And you also have bad decisions out of the 10th Circuit, out of places like Colorado and New Mexico, and the 11th Circuit, strangely enough, in a very big split decision out of the state of Florida and Georgia and down there in the Southeast, which is a crazy decision by Judge William Pryor, who's usually pretty good, but totally screwed this case up. But that's for a topic of another day, although I previously have covered that. Now, with that said, in addition to figuring out who are the people, because remember, the text of the Second Amendment reads, the right of the people to keep and bear arms shall not be infringed. So the first question is, who are the people? Well, obviously we know from Heller, because Heller used, among other things, Supreme Court precedent and dictionaries to define the people as all Americans. Obviously, 18, 19, and 20-year-old American citizens are part of the people as a matter of text. So textually, it will be obvious and a no-brainer for 18, 19, and 20-year-olds American citizens, who are the plaintiffs in this case, arising out of the West Virginia Citizens Defense League, which is the group that's representing the main plaintiff in this case. Obviously, they're American citizens, so they're going to be textually part of the people, which means what? Which means the burden is going to shift, obviously, under NYSERPA versus Bruin, the methodology of the Bruin case, the burden is going to shift to the government. That means that the text, the unqualified command of the Second Amendment, the right of the people to keep and arms shall not be infringed, will be enforced, period, full stop, unless and until the government can come forth with a historical tradition of firearms regulation that somehow shows that it is a long-standing tradition of somehow regulating or restricting or banning young adults, 18, 19, and 20-year-old young adults, from being able to acquire firearms or otherwise having full-blown Second Amendment rights. And that, I think, is not going to be doable, and we'll talk about that in just a moment. But before we get there, there's another critical decision that will have to be made by the Supreme Court in this case. So in addition to finding that 18, 19, and 20-year-olds are part of the people, which is going to be an important finding, the next important thing that the Supreme Court will have an opportunity to clarify when it comes to Second Amendment jurisprudence is this. Does the text of the right of the people to keep and to bear arms, which means to keep means to possess, to bear means to carry, does that textual language of the Second Amendment include the concomitant or the ancillary rights to acquire a firearm and or to purchase a firearm? Now, those of you that are interested in the ability to make your own firearms, this case will be extremely important to create an initial stepping stone to get to the right to make your own guns as codified by the Second Amendment, because the Supreme Court is going to have to decide whether or not the right to acquire and or purchase guns from these FFLs basically implicates the text of the Second Amendment. And that is going to be an affirmative answer. It's pretty clear that the right to keep and the right to bear arms has these concomitant or ancillary rights, includes the right to acquire, because we're not born with guns, so there's no way for us to effectuate and benefit from our right to keep and our right to bear arms unless we can acquire them in the first place. And the way most people acquire guns is by buying them in the commercial marketplace from federal firearm licensees, from FFLs. So the Supreme Court almost certainly, I believe, will say that, yeah, the right to keep and bear arms includes this right to acquire and the right to purchase, which again is another huge precedent in favor of our fundamental rights, which we want the court to say that. Then, of course, the next question is going to be, is there a historical tradition of firearms laws that somehow would justify banning or restricting the Second Amendment rights of 18, 19, and 20-year-olds? And this is where it's going to get quite interesting, because to begin with, the first thing that the anti-gunner is going to have to get around is that the Second Amendment was adopted, and you know when, in the year of our Lord 1791. And what happened in the year of our Lord 1792 was the exact same Congress came together and enacted the Militia Act, the Federal Militia Act, for the entire country, mind you, of 1792. The Militia Act of 1792, which applied to the entire country, defined the organized militia as including, among others, 18, 19, and 20-year-olds. And under the Militia Act of 1792, they were literally required to bring with you to militia musters your own long guns, your own rifles, your own shotguns, your own ammunition, your own cartridges, your own pouches, and so on and so on. So the idea that somehow there's a historical tradition of firearms regulation that says that 18, 19, and 20-year-olds can be restricted in their ability to acquire firearms has to fly directly in the face of that affirmative positive history from the Militia Act of 1792, which was a nationwide law. This is not pointing to some particular law in one state. This is literally was nationwide. And again, obviously, if the federal government thought that 18, 19, and 20-year-olds had an obligation to get these guns, it seems pretty hard to argue that they did not have a right to acquire them, because how on earth would they be able to fulfill that obligation to bring guns with them to militia musters if they did not first and foremost have the right to get the guns and then go out and actually get the guns to bring with them from home to the militia musters? So that's going to be a very big argument. But let's talk specifically about what the anti-gunner is going to do. And this brief by Adam Kraut of the Second Amendment Foundation and several lawyers over there at the law firm of Cooper and Kirk did a nice job of discussing this. And that is specifically this notion of commercial contracting. So just bear with me for 2 minutes. This is slightly complicated, but not that hard, and you will totally understand it once I explain it. And that's this. What the anti-gunners are doing in this case, and I would say it's kind of their best theory as to why you can ban 18 and 19 and 20-year-olds from having guns, and ultimately it fails for many reasons. You see, the theory they advance is this. They say at the time of the founding, there was this long-standing commercial contract. Listen to what I just said. A commercial custom, a commercial set of laws that allowed minors to be able to avoid or to void contracts that they had previously entered into. And they define minors for the purposes of entering into these commercial contracts as any child up until the age of 21. And the example, kind of to give you an example, is if, let's say, you're a 18, 19, or 20-year-old at the time of the founding. So the theory goes, and you went into a store to say, I want to be able to buy, that item for $5 or whatever it is, and the vendor sold the minor that item for $5. When the minor turned 21, the minor had the opportunity to go back to the merchant and say, I was under the age of 20, I was a minor, I was not an adult, and therefore I want to void the contract. And let's be clear, this was a contract or an option to void. It was a voidability option. The minor could go back and void the contract and do the swap and give the item back and get the money back and all that. It was a voidable contract if the minor wanted it. So this argument I don't think is going to work for the anti-gunners for several reasons. First of all, there's no evidence that this sort of voidability doctrine that allowed minors at the time of the founding to void contracts when they turned 21, there's no evidence this applies specifically to firearms. As you know, the Bruin methodology requires that the government come forth and bear the burden of showing there's a long-standing historical tradition of firearms regulation. This merely shows sort of a commercial contract rule dealing with commercial or consumer transactions, not specific to firearms. So I don't think this is really a historical tradition of firearms regulation, because there's no evidence that applies specifically to firearms. Moreover, and this is very important to understand, there was what was known as a necessary or necessity exception. Specifically, the idea being that while, for example, if the kid went in and bought something that was frivolous and wanted to avoid the contract down the road for the protection of the minor from unscrupulous vendors and merchants, that could be transaction could be unwound. But there was an exception for what were known as necessaries or necessities. And I would think, since a minor at the time, if you want to make and again, I'm making the argument for the anti-gunners here, a minor at the time, 18, 19, and 20-year-old, had an obligation under the Militia Act of 1792 to buy and acquire a firearm to bring with him to militia musters. It would seem to me the most obvious type of necessity, in addition to, let's say, food, water, drink, would also include firearms. And the reason why that's so important is firearms are viewed as a necessity or a necessary. The rule of voidability that I described earlier did not apply to necessaries or necessities. And since firearms are almost definitively, in my view, at the time of the founding, a necessity, how could you survive without them? I don't even think the voidability rule would apply. And never forget that there's that very important footnote in NYSERPA versus Bruin that too many people in the Second Amendment community don't mention. And I did not see it mentioned in this particular legal brief. I'm not criticizing them. I'm just making an observation. There's a critical footnote in Bruin that says specifically, to the extent there is historical ambiguity about what was going on, then that means the government has failed to meet its burden of showing an exception to the text of the Second Amendment, and the text prevails, meaning the unqualified command of the Second Amendment prevails. So here, I think at most you could say there's some sort of historical ambiguity, and that I'm giving the benefit of the doubt to the anti-gunners in all respects. But anyway, none of this matters, because let's just stop back and think. And this brief makes a very good point, and that's this. Even assuming for the sake of argument that at the time of the founding, minors up to 18, 19, 20-year-olds could be basically denied the ability to acquire firearms because of this commercial contract rule avoidability. Let's assume that's true. It actually doesn't do any good to advance the anti-gunners today in the 21st century. And the reason why is the lesson or the historical tradition, if you want to argue there is one, would be that there was a tradition of protecting minors, legal minors, from entering into transactions with firearms at the time of the founding, for the sake of argument. But today, what do we know about 18, 19, and 20-year-olds in the 21st century is that they're 100% not minors today. They can enter into contracts. They can buy homes. They can take out mortgages. They can get married. They can get tattoos, right? They can do everything that's needed for the purposes of being a full-blown adult. They can vote, of course. So even if you want to assume there's a historical tradition of restricting access to firearms by minors in American law, that will not save the anti-gunners today in the 21st century, because 18, 19, and 20-year-olds today are not minors. They're legal adults. And the last important thing that the Supreme Court will be able to resolve in this particular case in favor of the Second Amendment, setting great precedents for other cases down the road, is they will have to deal, I think, with the question of which is the key time period for evaluating the Second Amendment in terms of historical regulation of firearms, whether it's 1791 at the time of the founding or the late 19th century at the time the 14th Amendment was adopted. This brief does cite to a very handsome YouTuber with gray hair that you all know and love, and that, of course, is the Mark Smith article in the Harvard Journal of Law and Public Policy that makes the case that obviously, if you're an originalist and you want to understand the meaning of the Bill of Rights, you have to look to 1791 when it was adopted, and anything in the late 19th century, all that happened with the 14th Amendment is you took the meaning of the 1791 document and you applied it to new groups of people, specifically the freed African-American slaves, and also to the states and localities, restricting their ability to take away the fundamental constitutional rights of American citizens. But other than that, the meaning of the Second Amendment and the First Amendment has to be gleaned by looking at when it was adopted in 1791 and the original public understanding of the document back then. So all of these things will have to get resolved by the Supreme Court if they grant cert in this case. The first thing I want to see, of course, is what is the Department of Justice under Donald Trump going to have to say in response to the cert petition? Are they going to agree the court should take the case, or are they going to argue it should not, or what will they do? That will be the next very interesting thing. But I do think this is one of the cases involving the Second Amendment the Supreme Court is going to take this coming term. If I had to bet, this would be the number one case I would bet that they hear. But again, the history of the future has yet to be written, so we'll just have to see. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4boxesdiner. Don't forget to subscribe both to YouTube and to Rumble, and I look forward to seeing you all again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.